This call is subject to recording and monitoring. Press 1 to accept all communications from this inmate and cellmate. Thank you for using cellmate.
Hello?
How are you doing?
Doing all right. Did Kellen not keep putting money on your books?
He did, but I've spent it, and that's about it.
All right.
Okay, I'm going to read to you what I've written in terms of my jurisdictional statement. Tell me what you think. Okay, jurisdictional statement. Comes now appearing in propria persona, the petitioner, Adam Alistair Woodward Smith, petitions the Court of Appeals of the State of Arizona for the issuance of a writ of mandamus to compel the lower tribunal, Coconino County Superior Court, to respect the rights of the petitioner to meaningful access to the courts, the rights to self-representation, the right of confronting one's accusers, the right to cross-examine expert witnesses, the right to a fair, public and speedy trial, the right to an independent Rule 11 competency evaluation to be considered, the right to file motions with the court in propria persona, the right to be free from unwanted, hostile and ineffectual counsel, the right to receive mail from governing bodies while incarcerated, the right to receive mail from independent Rule 11 competency evaluators while incarcerated, the right to the presumption of innocence, sanity, and competency until proven otherwise beyond a reasonable doubt, the right to access legal tools, the right to meaningfully participate in one's own defense, the right to access Brady materials, the right to testify in one's own defense, substantive due process rights, and liberty interests to bodily autonomy. This petition is supported by the 1st, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and concordant provisions of the Constitution of the State of Arizona. This petition is also supported in case law by Floretta v. Cal, 42 U.S. Daybert vs. Merrillsburg Pharmaceuticals, Inc., 509 U.S. 579, 1993. Bounds v. Smith, 430 U.S. 817, 1977. Lewis v. Casey, 518 U.S. 343, 1996. Turner v. Safely, 482 U.S. 78, 1987. Brady v. Maryland, 373 U.S. 83, 1963. State v. Willits, 96 Aris 184, 1964. Strickland v. Washington, 466 U.S. 668, 1984. Snow v. Superior Court in and for the County of Maricopa, 183 Aris 320, 1995. United States v. Marbley, 410 F.2D 294, 1959. State v. Bishop, 139 Aris 567, 1984. State v. Vitello, 113 Aris 255, 1976. State v. Bush, 148 Aris 325, 714, 1986. Jensen v. Sin, 609 F.Sub 3D 789, 2022. Anderson v. State 135 Aris 578, 1982. Riggins v. Nevada, 504 U.S. 164, 1992. Dusky v. United States, 362 U.S. 402, 1960. United States v. Rodman, 446 F. Sub 2D 487, 2006. State v. Steelman, 120 Aris 301 585 P.2D 1213, 1978. State v. Verdugo, 112 Aris 288 541 P.2D 388, 1975. Trope v. Missouri, 420 U.S. 162, 1975. State v. Henderson, 2012, Aries App Unpub Lexus 797. Washington v. Luxembourg, 521, US 702, 720-21, 117 Superior Superior Court 2248, 116 Superior Court 2302, accepted only if the remedy by appeal
where the case was not put on the dockets. Don't forget about the third-party vendor.
the legal defenders office has claimed that the reason it's not on the docket is because this is a vulnerable case.
Okay, don't forget about the third-party vendor with the 13 board of psychologists, or 12, that took you out of jail and tried to do a mental competency evaluation with you without contract or agreement. And under Arizona law, you must be in court to have that competency evaluation, which was not proper procedure nor due process, it would appear. For special action petition, like Arizona's complaint for special action, emphasized that the challenged act falls into the recognized categories: failure to perform a duty required by law, parentheses, no discretion, proceeding without or in excess of jurisdiction or legal authority, act or decision that is arbitrary, capricious, or an abuse of discretion, and frame the issues and facts to fit those categories and the rule granting special action jurisdiction. You can only do a mandamus or a petition, so the petition cannot be in the mandamus. A mandamus and petition are separate issues.
But all mandamus are petitions under the rules of special actions in Arizona.
Oh, okay. Well, if that's the case, then it's a petition. So then frame the issues and facts to fit those categories and the rule granting special action jurisdiction. If you tell the jurisdiction, state or federal, and which appellate court, a jurisdiction-specific checklist can be laid out for you.
I found a statute that compels them to accept jurisdiction in instances of statutory special actions, such as ARS Section 36-546.01, review of court-ordered mental health treatment, defined as ARS Section 36-546.01, expedited appeal to the Court of Appeals. An order for court-ordered treatment may be reviewed by appeal to the Court of Appeals as prescribed in the Arizona Rules of Civil Procedure or by special action. Such appeal or special action shall be entitled to preference. An appeal may be taken from a mental adjudication and commitment where questions of law are presented and where the evidence is such that there is some reason to believe the trial court's findings of fact are clearly erroneous. In R.E. Capital Mighty Castle Hotel -3-3-85,146 Aries.435, 706 Capital Papa .2 Lower Delta 761 Court of Appeals 1985.
It's on the ground. Go ahead, keep going.
There is also a requirement for courts to accept jurisdiction in the instance of statutory special action such as ARS Section 39-121.02, defined as ARS Section 39-121.02,